up, everybody? It is Monday night, and it's time for the Monday conversation. Welcome in, everybody. Make sure to smash the like button when you come in. I am Brian LTL. Some people call me dummy. Some people don't call me dummy. And hey, how do you know I haven't talked to Karen Reed? But welcome in, everybody. It's nice to see everybody here in the chat. If you haven't subscribed, please make sure to subscribe when you come in and smash that bell notification so you get notifications when I go live. And this is Monday night. This is our Three Amigo conversation. We have a lot of stuff to get into. We're going to talk about Robert Brooks. We have an update in that case. We're going to talk a little bit about Brian Walshe. We're also going to go into a lot of the Karen Reed case and her civil case, and we'll get into that conversation. But I don't want to wait and want to get my guest up here really quick because we're a little bit late getting started. But let's do this. We'll bring in Attorney Nan Gallagher. How are you, Nan? How are you doing?
I'm doing great. How are you?
I'm well. And I'm really looking forward to getting into all of the topics this evening. And we'll bring in retired Mass State Police Todd McGhee. Todd, how are you?
I'm doing good. Hi, Nan.
Hi, how are you, Todd? I'm sorry to keep everyone waiting.
All good. We're ready. Hi, chat.
It's fine. It's like, I look at like our week goes by, it seems like things are quiet in and around Massachusetts, Norfolk County. And then all of a sudden, we get all this news, Brian Walshe case is going to be kicking off. The jury's been seated in that case. We have Karen's civil case. It just seems like things never end. Oh, and by the way, the McAlberts have opened up their own funding website to fund their legal battles. So, and Karen has just opened up a civil website to fight her legal battles. And if anybody does want to contribute, the link is at the top of the chat. But it's crazy. I mean, it just never seems like it stops. What are your thoughts on all of this? Does it ever go away? Does it ever stop?
It's strange. It's a good question. It's strange though, because as much as I'm sure we all want this to go away, just one thing after another, and it keeps unveiling more and more insidious problems and deep-rooted issues that while we want the whole situation to go away, we also want transparency and unveiling and try to get to the root cause to try to find solutions. And it does selfishly feel really good, having followed this case as you all have, to know that there's a reckoning, there's people being revealed for who they are, and I'm here for that. So all of these problems that we keep talking about, I truly believe that in time and very quickly, they're going to be resolved and good is going to triumph over bad.
Hopefully it does. Hopefully it does. Go ahead, Todd.
Yeah, the information is new and fresh. We're not recycling old information. We keep having this conversation because it's something brand new to talk about. So, to Nan's point, eventually this will come to an end, but right now the spigot is wide open.
Yes.
So wide open. You couldn't have said it any better. Let's do this. We have an update out of Marcy prison. And the other day, let me bring up this. Hang on one second. My computer's not. So, update in the Robert Brooks case out of Marcy Correctional Facility. That's upstate New York, Syracuse, Utica. 4 of the correctional officers in that case have formally been sentenced. And I'll read a little bit of this. And then, I'd love to hear your comments from the both of you because we haven't talked since this. So 4 former Marcy Correctional Facility officers were sentenced Friday for their involvement in the beating death of inmate Robert Brooks. And remember, these are the 4 that took the plea. They just took the sentencing and their sentences were rolled out the other day. And this is a quote from Judge Robert Bauer. He said, "I've never seen so many lives destroyed in one moment." And I'm going to play that clip in a second because the impact of that is so heavy in this case. Anthony Farina, Nicholas Alazone, who pled guilty to first-degree manslaughter, was sentenced to 22 years in prison. Michael Mashaw, who pled guilty to second-degree murder, received a sentence of 3 to 9 years in prison. And then David Walters, who also pled guilty to second-degree murder, was sentenced to 2 to 7 years in prison. All 4 men declined to speak in court. And here's a quote from Robert Brooks Jr. It said, "Last December, I watched as officers beat my father to death on camera. What they took from me and from my family can never be returned and made right. Still, 22 years in prison is a long time, and we are heartened that all these officers are facing real accountability, not just a slap on the wrist. To the officers Alizone and Farina, I pray for your loved ones never have to endure the kind of pain that I have experienced. All of this could have been avoided if you and your fellow officers did your job. My dad would be alive. I pray that this case teaches others that they can't treat incarcerated people like animals. I pray this case sparks real conversation about the need for change in our prison system that you are entering at this time wearing green instead of blue." Todd, what do you think about that comment?
Yeah, it's a powerful statement, by the son, and every word is spot on. Um, you know, Robert Brooks was doing his time. He was, going to pay his debt to society and then move on with life. And they robbed that from him. They stole that from him. And his punishment was at sentencing, not after the fact with a death sentence. So it's just horrible to see that human beings can treat each other like this.
I agree. Go ahead, Nan, jump in there.
Yeah, I mean, I'm happy that they've pled guilty and that there's convictions and punishment. But when you read statements like that and just try to put yourself in that family member's position and to actually have to witness video footage of the loss of a loved one, that it was an unnecessary unaliving. My heart bleeds for his family. And, I also feel like I was disappointed in the verdict that came down too. So whenever there's not a complete sense of justice, I don't know, as a true crime follower, I really do get disheartened. But I also will say, I don't think 22 years on the larger sentences is enough. It's just not enough. Robert Brooks was deprived of more than 22 years of his life. So how is that fair?
Yeah, I mean, we really don't know how Robert would have been after his sentence. Could he have been a productive member of society? Did this prison sentence, make him change his life and seemingly go on to do better things and bigger things in life? I mean, that's something that we'll never know. And the family and society was robbed of that. We don't know what Robert Brooks could have become after his time. And that's basically what he was doing. And the sad thing about it is he was almost done doing his time. He was almost done doing his time, and he was robbed of the rest of his life. So let's play this. This was Judge Bauer. I'm just going to play this small clip so everybody can hear it and hear the full context of what he had to say.
Stands alone. Is there anything that you want to say prior to the sentence? Well, I'll note for the record that the defendant waived his right to appeal at the time of his plea, so I'm not going over those rights again. I've been at this a long time, and I've seen a lot of terrible things in this room. I've never seen so many lives destroyed in a moment. The defendant is sentenced as follows. As to the conviction for manslaughter in the first degree, the defendant is hereby sentenced to a determinate sentence of 22 years in state prison. That is along with 5 years post-release supervision. In addition, there is imposed a mandatory surcharge, crime victim, and DNA fees, which will total $375. The defendant is committed for the term of the sentence.
Michael Mayshaw.
That's Robert Brooks Jr. right there in the middle, right here. Show everybody. This is, if I can get this out of the way. Nope, it's not going to cooperate. Right here. That's Robert Brooks Jr. It's just I mean, do you think that judge was happy? I don't think so. I mean,
He had more he wanted to say.
oh, I think so. I think he was in probably a very uncontrollable rage at that point, to see this. And like you said, he's like, I've seen a lot of horrible things, and this destroyed many lives, many lives in just under a few seconds.
But
It's
you know,
crazy.
Brian, I got to say this from a public safety perspective, that when you take your oath of office and you decide that this is my career path, you are then making a declaration that you're going to be above reproach. And to see this misconduct is, I think, worse than criminal. Criminals don't take an oath. Criminals just survive. I'm not condoning criminality, but they just do what they do on the street because they're opportunists, or that's just their way of life, and they don't want to reform and follow society rules. But when you're public safety, you're making a statement above and beyond the average citizen. And when you conduct yourself like an animal, it's just it's there's no words.
Yeah, I agree.
I
And I know we
always,
talked.
I
Go
always
ahead, Dan.
find, oh, sorry, Brian.
Sure.
I always find sentencing to be one of the most fascinating parts of criminal law, because judges have to, as we all know and hope, they have to remain impartial throughout the process. We may have recently seen perhaps intimations where a judge may not have seemingly been so impartial in some rulings, but when you have a judge who has to impose a sentence based on sentencing guidelines and can offer opinions like this judge just did, which were very brief. You know, he's never seen so many lives destroyed. I find that very interesting to me because it's where a judge is legally empowered to give some opinions about conduct. So I was happy to see that this judge did express himself a little bit. There's many circumstances that we could talk about on future streams about where judges really lay into the sentencing process. But this was a light way for this judge to say this is a disappointment. Lives were destroyed here, not only Robert Brooks, but his family members and loved ones. And I don't think I could sit there as stoically as his son, Robert's son, in the courtroom and just allow this to transpire without kind of jumping out of my seat. So I really admire him for composing himself.
Yeah, and look what we found out through reports up there, that this is a very tight community up there. It's kind of like everybody knows everybody, and it's not only going to impact just the lives that are involved in this. I mean, this spills out to friends and relatives and the community. And I just hope that this is a situation that's not forgotten, and it is used as an example to have some serious reform up there. And then what did we hear? I mean, just a couple of weeks ago, just after all this was going on, it was like someone walked into that prison. It was a preacher and took his life. So it's like there's a major institutional problem inside that facility, and it's probably not only going on in there, it's probably across our country. And it would be nice to have some other resources go in and look and say, okay, what can we do to improve, or what can we do to help our employees, or even just make better conditions for everybody in prison. Prison's not fun. I'm sure it's not a fun place to be. And I know, I understand it's punishment. It's not supposed to be a luxury hotel, but I'm sure there's probably things that you could do to help. So it's just a ultimate tragic story all around. One more officer is facing trial in January. We'll continue to follow that and see how this plays out. But I want to ask Todd really quick, and just going back to this, when we talked about Proctor's behavior, is this something that is a learned behavior when you get into this type of culture, or do you think that people like this have this inside of them and it comes out when they start doing this type of work?
I think it's fair to say that there's probably, given the circumstances, there's probably a little bit of both. There's that group think, that's a very real thing. How in a group setting, individuals will start to align their thought process. In this particular case, they align their behavior. And, when no one has the fortitude or the balls to be able to say, stop, this is enough, then the outcome is what we see here. That's where police reform, not just de-escalation training, but the duty to intervene. And we saw that, Brian, when we covered the Leroy's case in
Yes.
New Jersey, right?
Yes.
You
Yes.
saw that officer step in between Leroy and his lieutenant. That's an example of duty to intervene. Unfortunately, it continued on, but at least it was in his thought process, that particular officer. Had that been done in Marcy prison setting, we wouldn't be having a story right now.
Yeah, and the thing that aggravates me about that is the 3 that got off, and it's like,
Mhm.
you were part of that, and
Yes, they
that's your
were.
duty to intervene,
Right
and the
there.
jury just didn't see this, and that's what I mean, it's just it's so disheartening. All of these officers should have gotten something. I don't care. You're in the room. You have the duty to turn around and say stop. And that's in any case. I mean, even if you're just out on the street and you're watching someone getting pummeled to death or whatever, you have to step in and say, hey, like you got to
Absolutely.
stop. You got to stop.
Brian, just a quick question for you, because as I'm listening to you both and I'm thinking about the officers who were acquitted,
Mhm.
I'm wondering if you have made a FOIA request of the acquitted officers' disciplinary records to see if they have faced any administrative ramifications for their conduct, because what they were acquitted of were criminal charges.
Yep.
But perhaps they received some type of administrative reprimands, discipline. It's probably, because this case is so near and dear to your heart and you've been focusing on it for months, I'm wondering if it's worth throwing out a public records request just to see, because that may provide some more answers and a sense of justice or solace if we can find out if they've faced other non-criminal ramifications.
Yeah, it's not a bad idea. I mean, we saw that in Proctor's IA report,
Right.
all his list of his, I guess, infractions or whatever they called it. We saw that list, and there was one incident that I wanted to dig into. So that's just something that we definitely can go back to. All right, let's shift gears here. Let's talk a little bit about Brian Walshe. Let's see. I lost my article. Dang you. Hang on one second. I find it interesting. And Nan and I actually talked about this the other day about Brian's case, and it was kind of shocking. You have the first day of jury selection, and he pleads to 2 charges, and that was conveyance of a body, I think they called it, which would be moving a body, and then lying to police. And I said, well, this is really interesting now, and this is really creepy too, because I haven't seen this photo until now in this article. This is Brian Walshe inside either a Lowe's or a Home Depot, literally, bringing out, a kill kit of some sort here, in my opinion. And anyway, I just find this interesting. He comes in, he pleads to these charges, and now he's just basically facing a murder charge. And Nan and I were talking about this, and I said, what if he turns around now and his defense team turns around and says, oh, well, he walked in the house and his wife, had a medical emergency, and he didn't know what to do, and he panicked. And we know that he had a psych evaluation. It was in Bridgewater for almost 20 days or 14 days. He turns around and says, oh, I had anxiety. I didn't know what to do. I was panicking. So I just moved her body, or it's a slip and fall. She slipped and she fell. I didn't know what to do. Nan, what do you think? Could this be possible that they go down this route to try to just create a shred of doubt? Remember, we just had like a little tiny bit of doubt in a juror's mind, and this guy walks clean.
Yes, and I know when we were talking about this kind of real time going, what is going on? And I got PTSD because I've had this happen to me on the quote eve of trial, where things have been changed and all of a sudden you're like, oh my God, I've got to change my trial strategy. I've had that happen in civil settings. I've actually done that to the prosecution in criminal settings. So there's strategic reasons why his team and he have decided to do this, I do think that it's likely he's going to shift or at least present his position that he stumbled upon her body and panicked and had a very predictably natural, I guess, reaction to it and said, "Oh my God, what do I do?" I wouldn't have done that, but maybe that's the story he's going to tell. But I do think this kind of 11th hour gerrymandering of the playing cards, so to speak, is done with the purpose of confusing the prosecution, making them have added pressure on them to now really prove that he is indeed the one who, quote unquote, unalived her. But also, I do think that this will lend itself to hyper scrutiny of his electronic data footprints. You know,
That's a good
what
point.
was he doing in terms of before the unaliving to plan? Was he, you know, are there text messages or searches on Google or other search engines on both his devices and that of one of his children to show that there was malice aforethought or some type of intentional, as they call it, mens rea for the crime of murder? But time is going to tell, and there is enough time because they're still selecting a jury. I believe they're set to start Monday, December 1st, if I heard correctly. So
No, jury's been seated.
have
Yeah,
they
yeah,
been
the jury's
seated?
been seated. Yeah,
Okay, yeah. So you follow this much more assiduously than I do, but there's a little bit of time in terms of when everyone starts the case in chief as to what the prosecution's going to do. But all you have to do is convince one juror that
A little bit of
you
doubt.
didn't do it. A little bit of doubt is what can get him acquitted or possibly have a mistrial, which I hope is not the case.
Yeah, Jay Blazin says, wasn't her body dismembered? Yes, it was, but they don't know where it is. They couldn't find any traces of it. He said, and he believes the jury's still going to find him guilty. I do too, but again, I mean, Massachusetts juries have been wacky.
Yeah, you never know. You never know what you're going to get. But to Nan's point, anything new that he's going to say is going to contradict even the circumstantial evidence that they have. You know, that doesn't go away.
But you know what's another interesting point, Brian and Todd, is that he pled guilty to the intimidation of a witness and the issue involving the body. Okay. However, this was what's called a non-negotiated plea. If I were the prosecution, and I have never been a DA, but if I were the prosecutor, I would have argued to this judge, you know, we oppose this entry of the plea unless he comes forward and reveals where her body remains are found. Because if he does indeed, he pled guilty to mishandling her body after her
In line to
passing.
police.
Yeah. So why would he, you know, I guess it's a very simple analysis here as far as I'm concerned. You don't need to be a lawyer to even have this analysis. Why should he be able to plead guilty to that without saying, and this is what I did with her body and here it is, so that her family can have the peace to, you know, honor her life, bury her remains, or whatever would align with her religious preferences. He, as far as I'm aware, he has not done that unless that's somewhere behind the scenes.
Todd, what were you saying about the first degree? You can't plea in Massachusetts? You just found that out?
Yeah, apparently in Massachusetts, a defendant cannot plead guilty to a first-degree murder charge because it carries a mandatory of life imprisonment and no parole.
Wow.
I did not know that.
I didn't either.
It's a Massachusetts thing. It's not the case across the country.
Well,
So
there's a shock.
Yeah. Yeah.
You're saying things are unique in Massachusetts?
Massachusetts, right? All those weird things that happen, right? Let's just read a little bit from this. Brian Walshe is seen on surveillance footage at Rockland Home Depot buying a utility knife, a hatchet, two 12-pound bags of baking soda, and other items on January 2nd, 2023. God, that is so haunting. And it was funny. Todd and I were saying when we were looking at this before we came live, like Todd was saying, he's got that distinctive bone structure in his face. You just know it's him. And I said, and the hair. It's that and the hair is just is all him. That side part Mo Howard Three Stooges haircut. It says by the time investigators found the surveillance video of Brian Walshe dumping large trash bags in the dumpsters at South Shore in early January 2023, it was too late. The bags, which Walshe has now admitted containing the body parts of his wife Anna, had been picked up and transferred to Southern Massachusetts Resource Recovery Facility. Say that 5 times fast. In Rochester. They're shredding and incinerated on January 8th. Still, investigators traveled to the dumpsters in hopes to find valuable evidence. Here we go. Look who's in the news. It's determined there was none. An affidavit prepared by former Massachusetts State Trooper Michael Proctor reads, and other evidence the investigators collected at a dumpster outside Brian Walsh's mother's apartment in Swampscott, including clothing that had been worn by Anna, her COVID-19 vaccination card, and towels with red-brown stains, and a hatchet and hacksaw, according to the prosecution's theory of the case. Anna's remains have never been found. It has appeared that they cannot be recovered. Still, her husband is on trial for killing her. It is normally to challenge a prosecutor to prove the murder took place without a body, experts say, but its unique circumstances in Walsh's case may work against the defense. It is not an issue because Walshe is conceding to disposing of her, said Mark Betterow. Oh, look at this. Mark Betterow quoted in the article, New York City-based defense lawyer, a former prosecutor. That evidence is going to be admissible as consciousness of guilt. Had Walshe not pled guilty to disintegrating a body, his defense could have argued that Anna Walshe was simply missing and not dead. But in fact of the case, particularly the Google searches prosecutors say Brian Walshe made, and those are some horrifying ones, in the early mornings hours of January 1st, 2023, made it possible to not admit to moving his wife's body. Let's see, 10 ways to dispose of a dead body if you really need to. Dismemberment is the way to dispose of a body in critical part of the government's case against Walshe. Let's see. Scenario might have been very different 30 years ago, he said. So-called no-body murder cases are rare, but just last year, New England has had a home to a high-profile murder featuring a criminal defendant who admitted to moving a person's body that was never recovered. That's the Adam Montgomery case. I'm just going to say this, who was eventually convicted of killing his daughter Harmony in the back of a car in a family outing. She has similarities to Walsh's case, explained Caroline. Let's see, the judge. Yeah, I mean, I don't know. Again, you don't know what you're going to get with a jury. You just don't really know. And then all it takes is just a little bit of shred of doubt, and that's it.
Yeah.
Walks.
I mean, they have to, with a no body type of case like this, the prosecution actually has the laboring oar here. It's not going to be a slam dunk. I personally have my views as to whether I think Mr. Walshe committed this crime, but it's not as simple as, well, it sure looks like he did it. So they're going to have to meticulously lay things out. And yes, while evidence does come in that he disposed of the body, which is evidence of consciousness of guilt, disposing of a body does not necessarily mean, and the court will probably be very constricted in how they allow that to come into evidence. It does not necessarily mean that he unalived her. So I want everyone to watch that trial, because it's going to take some very strategic maneuvering on the part of the prosecution to navigate its way through by just proving an M case against Mr. Walshe with already having received a plea as to the other 2 charges.
Todd, do you think the Proctor problem is going to factor in this case?
Coming in tonight's show, I've been thinking about that, and given last week's confessions by Brian Walshe, not to minimize Proctor's exposure to this case, but I think it's going to be minimal. I think the jury is going to hear the case as it's presented, and they'll probably lean more towards all of the circumstantial evidence as opposed to letting Proctor be a distraction. That's the word I was looking for. I think at best it'll be a distraction. You know, that image that you had, Brian, that's powerful. That's a powerful image for the jury to see. You know, the statements that were made, the Google searches that were conducted by Brian Walshe, that's powerful evidence. And even if there's some bias on the part of Proctor, I don't think it's going to be substantial enough to sway the jury that his conduct was egregious enough against Brian Walshe.
Well, that's if the jury gets to see it, because we know how
Mhm.
things usually tend to act here in Massachusetts. There's a lot of things that are suppressed from the jury. And speaking of suppressed, that takes us to our next segment, which is a good segue here. We have sidebar transcripts that are going to finally be released, and I want to give attorney Corey Hopkins a big leg up on that, and a phenomenal job. And I've had some correspondence with her, and I'm sure a lot of people have just recently. But I want to commend her on her work for pushing back against this and basically putting out a lawsuit and saying, look, we want the transcripts of Karen Reed's sidebar to be released. It should be transparent. We should know what went on in those sidebars. And as far as, if we just go back and look, I mean, the totality of time that case was, basically tried in sidebars was probably like 60 or 70%, and we have the ability and the right to see this. So I'll read a little bit of this. So Judge Beverly Canone cleared the way to release the sidebar transcripts from Karen Reed's criminal trials. The sidebar can provide valuable insight to both sides' legal strategy during the trials. The first trial ended, and I was dying to see the sidebar, said Corey Hopkins, an attorney from North Carolina who followed the trial. She described herself as a supporter of Karen Reed. When Norfolk County District Attorney Michael Morrissey's office refused the public records request for the sidebars, Hopkins decided to sue. Quote, I guess that's how badly I wanted to see them in those sidebars. Sidebars give the judge and attorneys a chance to sort out legal issues without the jury or public knowing in real time. However, sidebars are recorded and eventually transcribed. Canone, who intentionally sealed the sidebar transcript, ordered them to be made available, with the exception of any sidebars when jurors or juror were discussed. Essentially, they're agreeing to the relief that I requested in my motion, Hopkins said, and that they are going to start producing the transcripts within 30 days or sooner. They may play a role in upcoming civil cases involving Reed in the family of John O'Keefe, along with several witnesses and police investigators. A virtual hearing for the case was held on Friday. First hearing, and we're going to talk about this. Let's see. Obviously, we wanted this to resolve itself months ago. All right, we're going to talk about Karen's civil case here in a second. But good on Corey. This was great. And it's funny, not only that, it's actually opened up some other things too. We're going to talk about Alan Jackson coming at Michael Cox here in a second. But Nan, what do you think about Corey just saying, hey, because I think a lot of people just get that message, like someone like me, an average citizen, when I put a FOIA request in, they deny it. They say, oh, if you want to challenge it, and I might not, and I don't have the power to sue. But she's just like, no, I'm going to sue. I'm an attorney and I want to see this. How does this make you feel?
I love it. I was actually talking about this on the Grace Curley show with Mike Crawford a week or two ago, and I love what Corey has done, because any citizen can file the same type of lawsuit. They can make the same type of public record request. They can be delayed or put off by whatever governmental body is doing so. And she just said, no, I'm going to sue. So she is a queen. I'm extremely impressed. And also, they pushed back at her. They revealed, which
big
is
time.
it's a public bit of information if anyone looks, but they revealed her bar ID number. There is an implication that she was kind of gently or not so gently being threatened because how dare a lawyer from North Carolina have any say in our jurisdiction? What she did was completely proper. This is just more delay tactics by the Commonwealth or by the county or any other subdivision up in the Commonwealth to just push back and delay things. I'm extremely happy that this information is going to come to light. There are sidebars that I'm very interested in, ranging from even the most simple of issues on an evidentiary basis to more complex ones, some of which I witnessed while I was sitting in the courtroom. So kudos to her, because if people don't take risks like this and stand forward and say, I'm going to do this, I'm going to assert my rights as a citizen of the United States to request records, then you don't get changes like this. Had she not filed that lawsuit, those sidebars would still never be released.
Yeah. Todd, we deserve full transparency, correct?
Full transparency and more information to talk about as we go into the new year.
That's why I know you love it.
Yeah.
I want to just pull this up really quick too. What do we got here? I just don't want to share the wrong screen. Okay, this one here. I saw this and I found this to be kind of funny. So it says, according to the respect of the plaintiff's public request for trial sidebar conferences in the Reed case, and this is Judge Canone, in the Reed case and the NDAO agrees that it will not charge the fee of the plaintiff to produce the sidebar transcripts in its possession from the Reed case under, and there's the law. It says once, I love this. This is what I wanted to say. Once the universe of the sidebar transcripts are in basically the possession of the Norfolk County District Attorney's Office, and they are identified, the NDAO will advise the plaintiff of the amount of time necessary to review and produce the sidebar trial transcripts, and by the date in which they will be produced. If the universe of records is so voluminous, meaning large, that they will be produced in batches in a rolling basis, that the NDAO will produce the first batch within 30 days after this stipulation is filed. I don't believe it at all. I don't believe it at all. I think this is going to take forever to get out into the public.
Yeah, I can offer some commentary here. First, it does take a little while to produce transcripts, meaning the court reporters to transcribe them. With that said, I think they're already transcribed because there were possible appeals being envisioned on certain issues and possible civil rights actions, which we're now seeing coming to light. I think they were already transcribed. But in addition to that, when you have this kind of rollout of batches of the pure amount of sidebars, I'm going to just give some post-trial commentary here. There wouldn't be such voluminous amount of sidebars to transcribe had Judge Canone properly ruled on evidentiary issues during the trial. She had sidebars on everything. She, in my professional opinion, made incorrect evidentiary rulings throughout that trial. Many times she did not allow certain objections to even be discussed or ruled upon in the presence of the jury, which can happen and is proper in some circumstances. So she created the sheer volume that she's now concerning herself with the tremendous rollout of it. But it's going to take forever. Everyone should pace themselves if you have some expectations.
Oh, yeah. I mean, I have FOIA requests that are waiting 6 months in queue.
Yeah.
So I don't think they're going to be very diligent. I don't think it's going to be, it's going to take a very long time to figure out where those are. We don't know where we put the files. And then supposedly 30 days later, they're going to transcribe the stuff. I don't see it happening, but I love it. I want it to come out immediately so this can be used in Karen's civil trial, because this is information that her defense team can use to get justice for John O'Keefe. That's the point of this civil trial. I want to see those defendants be put under a deposition, and I want them to have to answer the questions, the tough questions that they were able to hide behind in the criminal trial. you know,
Right.
and you're familiar with this practice, Nan, with civil trials, is that you get to hear everything. You
Yep.
gotta answer to the truth.
It's a new ball game now, and all that stuff that was suppressed, it's going to be the opposite. And that's what Alan Jackson and team wants, and it's going to tell a whole different story.
And one other point on the sidebars is that I have a sneaking suspicion that some of the evidentiary issues that were discussed in sidebars, Judge Canoni ruled inconsistently on some topics. So I have a feeling there's going to be these, quote, off the record discussions on these objections where she took one position on one issue and a different position on another. An example being where she had issued a ruling that only a medical doctor could offer opinions on causation.
Remember that.
But then thereafter, I forget which expert it was, she was saying that I don't remember, one of the prosecution's experts could offer opinions on causation, and he wasn't a medical doctor.
It was going to be, I think, their dog bite expert, and I could have that
Yes.
wrong. Right.
No, I think
And
that's
maybe
right.
The chat
And
can clear that up.
and
Yeah.
his name is escaping me. But yes, so that ruling in and of itself, which I believe there were sidebars surrounding that, concerned me. Crosby,
Yeah,
thank
Crosby,
you.
they said changed in trial too. Correct. Yeah.
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 So if we see with a critical eye as these roll out that there is an inconsistency in how she ruled, that will add fodder to Karen's civil rights action, because she can even make an argument later that, like, look, the judge was even handling some of the simplest legal issues in a very haphazard and inconsistent manner. So these are very important, and the timing is ripe for this type of disclosure.
Yeah. I love this. Is I can't wait to see the sidebars. When Dr. Lepazada mentioned the dog bites, laugh aloud, and Canone wouldn't allow it. She had every right to opine on it, in my opinion. Absolutely. And then Debbie saying Alan was on Billy Bush tonight, and he said he was very much looking forward to the depositions. Oh, I am too. I am too. I mean, you want this. This is the point behind, continuing to support Karen in her civil fight. This gets us one step closer to getting justice for John. These people are going to have to sit in a room and have to answer the tough questions where they were able to hide behind their lawyers in the civil trial and hide behind the evidence that Judge Bev suppressed. A lot, people don't understand the amount of evidence that was suppressed in Karen's trials is ridiculous.
Yes.
The amounts of evidence that was suppressed. They're not going to be able to hide behind that in the civil trial. You have to answer the questions. So check out civil depositions. They're really interesting.
The civil depositions are going to be fire. I heard Alan say that on, I don't know if I heard it on Hot Mics, but I definitely heard him say that with Brother Counsel, and he is right. Oh, I glitched, Todd. Okay, it's a normal night for us. But he is right, because the way it works in a civil action is that everything is to be disclosed or discovered. You can ask all the questions, barring very limited exceptions, in a deposition, which is an out-of-court testimonial proceeding under oath. Whether those revealing information are admissible at trial is another story, but you get to find out all of the body of information during the depositions. And then as in limine motions are filed as trial approaches, a judge will make a ruling on whether something is relevant or too prejudicial versus probative, but it's all going to come out, and it's going to be very revealing. And it looks like, from what I did see, Alan Jackson is extremely excited to ask some more questions, and I'm here for it.
Yeah, the depositions are going to be wide open. Nothing's off the table. And they're gonna drill, baby, drill. They're gonna just, keep uncovering each rock, find out what's underneath there, count how many worms there are, and they're just gonna keep pressing.
And there's no protective order in this case that I am aware of. So technically, There's no reason why any deposition transcripts from the civil cases, meaning the case, the wrongful death action, and the action that Karen has filed, which may be combined with it, if there's a ruling to combine that with the wrongful death action. There's no reason why those deposition transcripts cannot be made public. So that, I don't know if the attorneys will disclose the transcripts, and or if they're video recorded, but there's no privacy that I'm aware of, and no court order that would permit them to remain private at this time. So they can be disclosed as they are produced.
I'm just tired of, like, you know, we have these rights to go out and get information under the Freedom of Information Act. You know, it was like something today too. I requested body cam footage of a case that I covered. So I FOIA'd the FBI, which was a little nerve-wracking, but they got back to me in a very timely manner. So they know who I am. They know all my details. There's probably a white van out in front of my house right now.
Ice cream truck.
Right, ice cream truck. I FOIA'd the FBI because I'm trying to get body cam footage of an arrest, and that was Anthony Farah, and that was a case that I followed here on my channel quite a few years back. He was arrested for essentially embezzling, you know, $6 million of investor money, and a lot of merchandise, very high-end watches were taken in that crime as well too. And they ultimately end up nailing on wire fraud and mail fraud. They don't like when you mess around with the mail system and wiring money. But he ultimately ended up going to jail. He's serving a couple of years in jail. And, you know, I knew that the LA Police Department was involved in his arrest, and they were coordinated with the FBI. So it's like, I just want to see the body cam footage. And they literally come back and like, oh, under the privacy rights and stuff like this. I'm like, privacy rights? I'm like, the guy committed a crime. He's convicted. Release the body cam footage. I want to see, you know, when he was arrested, and people should know, you know, what happened in that situation. You know, it's like, oh, under the privacy rights. I hate all this shit. You know, we have the laws that we can go out and do this, but they always hide behind, you know, these other laws. Oh, well, it's privacy, or you can't get to this, you can't do that. But then it takes people like Corey Hopkins to say, yeah, no, we're gonna challenge that. And guess what? They end up, you know, bucking up and releasing it. So it's annoying. I don't know.
And a
Just
lot
kind
of
annoying.
people, you know, they throw around terms like privacy rights and, oh, we're not going to disclose this because of some reason. Unless people rage against limitations, you'll never really truly find out. And Corey did that. Corey's like, no, I want these. I'm entitled to these. I'm also entitled to disclose them. I'm entitled to put them on Twitter if I want to. So there's nothing wrong with what she did. And she used her legal acumen and experience to do that. And I'm extremely, very, very proud of her. I think she's a badass.
Yeah, I was like, today, I got this from the Beverly Hills Police Department. They quote, the body cam footage requested is exempt from disclosure pursuant to the government code section of 7923.600 and must be obtained pursuant to the subpoena or a court order. You know, these are just the things they hide behind. And
Well,
it's very annoying.
But that's the thing. They can be disclosed if what you were told is true. If they can be disclosed pursuant to a subpoena or court order, what the implication is there is that there has to be a pending lawsuit. So that is kind of what Corey did. Corey filed a lawsuit to give her subpoena power, or to give her a means to procure a court order. Sometimes a very simple lawsuit can be filed to get the power to subpoena. So maybe we should have a discussion offline, Brian. And
so, or how about this? Any of the people that have been scammed by Anthony Farah, the timepiece gentleman, and you're watching this right now, if you file the lawsuit, reach out to me at letstalklivepodcast@gmail.com, because I could use that to get the body cam footage and get this out there public, because when he's released from prison, I want people to know who he is, and we should be able to expose them and put them out there so they don't get back in bad business deals with this character. So
right.
That's a good point, Nan. Very, very good
Yeah,
point.
lawsuits are a very useful thing, especially if you know how and when to file them.
All right. Well, Corey, again, shaking the tree in Norfolk County, inspired Alan Jackson to write a letter to the Post Commission and talked about Michael Cox. And so Karen Reed's lawyer claimed Boston PD commissioner was caught in a lie, how officials responded. So the leader of the Massachusetts Police Oversight Board said that it had no authority to investigate the commissioner of the Boston Police Department in a letter sent on Thursday, weeks after the defense lawyer of Karen Reed asked the body to begin one. Alan Jackson, the defense lawyer, called for an investigation in a letter he sent last month. His letter came after the email exchange he made publicly by, wow, look at this, Corey Hopkins, a lawyer out of North Carolina who supported Reed's innocence online, showed Commissioner Michael Cox knew of his department connection to the Reed case despite the remarks to the contrary. It says, in a letter provided to Boston 25, Jackson wrote that Cox was caught in a lie and not just a small one. Jackson asked the Post Officer Standards and Training, or Post Commission, to open an investigation into Cox, but Post Commission Executive Director Enrique, I think it's Zuniga, said that the agency has no power to investigate. And look at this, a civilian executive like Cox. Go ahead, Todd. I know you want to speak on this one.
Didn't see that coming. I did not see that coming. But you know, it's just another angle they're going to play, and they're going to insulate whoever they choose to insulate, and it's out there. They can't reverse it. We all know he lied. So
yeah, I mean, we have the videos. I mean, and I have that breakdown video. If you haven't seen it, it's like a 9-minute video on my channel where we compare Cox and Veruca. I always say Veruca Salt. Dever. But that back-to-back, that testimony, Cox like, oh, I didn't even know anything about Karen Reed. I was in Michigan. And come to find out, when Corey released the email, he did know about it because he was prepared to talk to Dever about that particular situation. So
it's all documented. It's all documented in internal memos. And, it's just when you expose even the top people, the top brass, you just start shaking your head at. Again, I shared this with Brian offline. This one single case, I'm amazed at how many law enforcement so-called professionals have been discredited and dishonored.
Is it disheartening to you though, Todd, like being a former, a retired Mass State police officer and seeing all this? I mean, does this stuff dishearten you?
I've seen misconduct throughout my career, and it's just the volume, right? You get a bad apple here and there, right? They surface, they expose like any other profession, but all of these individuals connected to one trial, to one case, I'm amazed.
You just shake your head. Not here we go again, right?
Yeah.
And the fact that the city of Boston is involved intrigues me. Yes, Brian Albert worked there. O'Keefe worked there. Dever now works there. Cox is the commissioner there. But this was Canton. This was a suburb. The crime allegedly was committed by a resident not of Boston, but of a suburb of Boston. So, like, the fact that Cox had any intention to lie about it and get involved and or tell Dever, Veruca Salt to do the right thing and to really double down on that in an interview with the news thereafter and say, I was in Michigan. Never put those two words together. He sounds like a buffoon. That I find fascinating. But Brian, if I may, I have a couple questions for Todd, because I've been thinking about this since this came out about him, Cox being I think the term is law enforcement executive. I was wondering if you have any experience with or knowledge about law enforcement executives who hold positions like this as chief of, or commissioner, commissioner of departments like this in metropolitan areas. And the follow-up to that is, I wanted to know if you have any opinion on whether Cox's misconduct might fall under the auspices of the Office of Police Accountability and Transparency, even though this may not be perceived to be a Brady related issue. Like, what are your thoughts on this? Because I've been thinking about wanting to ask you these questions all day.
Yeah, thank you, Nan, for your first question. And I can speak firsthand for Colonel Noble for the state police in that executive seat. He's an appointment by the governor, and like the Commissioner Cox for Boston, he serves at the will of Mayor Wu, and so that would be the consistency of a civilian executive that oversees the departments respectively, state and local. As well as the chiefs of police also serve. There are chiefs. When you look at the rankings within the Boston Police, there are chiefs that hold seats as well under the commissioner, right? So they also would I believe would serve under the mayor. So that's that one piece to answer the executive civilian side of
Right.
things. As far as a blatant lie like this, he's still subject to the policies, procedures, rules, and regulations of the police department. That he doesn't escape that by being a senior member or a senior manager. So there should be some exposure to misconduct, right, just within their own body of work that we would call policy, procedures, and rules and regulations.
Even if he's not a sworn peace officer?
Yeah, you're employed by the department. The department has standards, and I would think that just because I'm a certain rank doesn't mean that I have to be forthwith and honest. That
Yeah.
doesn't make sense to me.
I have another question for you.
Go for it.
Pardon me, Brian. He's such a breath of information. Do you have an opinion, Todd, as to whether someone like Cox, who is not a sworn peace officer, as a law enforcement executive, in general, lacks a certain amount of experience, granular experience, to be heading a large department like the Boston PD? In other words, if you're the commissioner of the BPD, but you're not a police officer, are you as an individual missing a core set of experiences that give you all of the bandwidth you need to properly rule this department, which I believe he said is like 3,000 or more employees?
3,000. Yeah.
Yeah, counting the civilian employees, it's around 3,000 under the BPD. Cox was a police officer. He was a patrolman. I didn't follow his career, so I don't know how much management experience he has, if he ever made it to the rank of lieutenant or captain. I'm assuming so, which would have made him a viable candidate, way back when they were looking to hire for that position. He would have had to have something substantial, or he's incredibly connected politically. But he does have a law enforcement background.
Got you. Thank you.
Yeah, but then you just have to ask the question, like, who's going to really challenge him?
Yeah.
They're just going to bury this and make it all go away at the end of the day. That's how I feel.
That
I
was
do
Brian,
too.
that would be in the purview of the mayor's office. And if she's going to let it just fade away, to your point, nothing's going to happen.
Yeah, and I mean, look what's been happening to Boston. I mean, it's not very good down there lately. So I don't think that she's going to challenge it. I just don't think. I think this is going to be buried and swept under the rug.
Yeah,
So.
look the other way.
It's the mantra in Massachusetts, I guess.
Nothing to see here.
We need to change the state slogan to that.
No, we need to crack
Do the
down
opposite.
on all the corruption that goes on here. And get get good people like Todd in these positions. Todd, you need to come out of retirement and start
Agreed.
leading these friggin' people.
Agreed.
Oh my gosh. All right. Karen Reed's civil trial. Let's talk a little bit about this from Court TV. Wrongful death lawsuit against Karen Reed is facing delays now that Reed is involved in a second lawsuit in a different county. Reed was acquitted on murder charges. Okay. While Reed was found not guilty of criminal responsibility, O'Keefe's family has filed a civil lawsuit claiming she carries civil liability for a wrongful death and emotional distress. Defendants in that lawsuit also include 2 bars where Reed and O'Keefe and their friends have been out drinking for hours before his death. Reed was, who is steadfast, maintain her innocence, excuse me, in O'Keefe's death, has pointed to the people that were inside the Canton home, and they are known as the House defendants. At the hearing in September, Reed's attorney said they plan to add additional parties in the lawsuit, including disgraced former trooper Michael Proctor and his group of friends who were inside the house. And a group of friends were inside those. So those friends include Albert and McCabe families, Brian Higgins, who also testified at Reed's criminal trials. Quote, obviously, we wanted to have this all resolved months ago, Mark Diller, the attorney for the O'Keefe family, said at Friday's hearings. Unfortunately, it wasn't until Monday night that defendants withdrew their motions and started on the different track with different mindsets. Nan, can you talk a little bit about insurance lawyers, how they want to kind of move and settle very quickly in situations like this? They don't want to get to depositions. They don't want to get to the raw facts and the truth. They don't want justice for John O'Keefe. They just want money in this case. And that's why I'm so glad that Karen has opened up a civil defense fund, and that is pinned to the top of the chat if you'd like to donate to that, because this is going to help Karen continue to fight back, because there's lawyers cost, certainly cost money for Alan Jackson and his team to come out. And you're going to pay up a lot of fees up front from what I know about civil cases. There's experts that come in to testify in this as well. And you may have to see some of those experts that testified, excuse me, in the criminal trial come back to the civil trial, and depositions cost money as well too. Talk a little bit about that.
Yeah, I've got a lot of opinions on this. So first off, what I will say is I served as an insurance counsel for many panels for many years when I did civil work, and civil in the field of civil law. And if you work for insurance companies, it's an interesting road to toe. I've worked with a lot of attorneys who are on insurance panels, and when you have to think of it this way, the attorneys who are engaged by insurance companies, their client technically is the client, but they are beholden to the insurance company. They answer to the insurance company, they bill the insurance company for their time is scrutinized by the insurance company, their time is shortened and abbreviated by the insurance company. So there is inherently an incentive for early settlements, minimal work to be done. It does not mean that all insurance attorneys do a bad job. It doesn't mean that, but someone, meaning Big Brother, the insurance company, is looking. I have found that when you do insurance work as an attorney, there's a little bit of a conflict because, you want to represent your client, but the insurance company may limit what they want you to do on the case. That is why it's incredibly common for clients, for example, perhaps Karen Reed, and I have no knowledge that this is the case. Clients may say, you're not doing enough for me, or I feel like you're not fighting hard enough. Plus, insurance policies only cover certain things. So while Karen's defense in the wrongful death action may be covered by her insurance policy, whether it's her automobile or her homeowner's insurance policy, meaning the carrier or carriers will assign her counsel. It may not include a complete defense, and it's certainly not going to include any affirmative claims that she wants to raise against other defendants, meaning add a third-party complaint or add counterclaims against additional defendants in that matter. That wouldn't be covered by insurance. She's going to have to pay out of pocket for that. She's also going to have to pay, likely, out of pocket for any additional attorneys that she has to engage. So if she's engaged, for example, Alan Jackson, Liza Little, or anyone else who's not assigned by her insurance company, she has to pay hourly out of pocket for those attorneys to advance those claims. And she has this separate lawsuit, which has not been combined with her wrongful death action as of the date of this stream, that may very well not be a contingency case. I will tell you, I have filed many civil rights actions in my 25-year career, and I have taken none of them on a contingency. I would never take them on a contingency. At best, I would take them on a hybrid fee arrangement, meaning I will take a partial contingency on any potential settlement or judgment, but I will also charge you hourly at a reduced hourly rate. So I am humming along, collecting for the time I'm putting in, but in giving you a reduced hourly rate, which you will pay me, I will then take a partial contingent cut of your verdict. So I want to just dispel some information that I've seen out there, respectfully disagree with it. Karen Reed is very likely, and I don't know firsthand, paying out of pocket for her attorneys to, or at least additional attorneys, to defend her in the wrongful death action, to advance the claims that she has filed against the House defendants, pardon my dog, the House defendants and other anticipated defendants that are coming in, plus the sheer cost of experts alone, the deposition transcript fees, the court transcript fees, all of the costs that will go with travel of those experts. It is an exorbitant amount of money.
And I'm sorry to cut you off.
No,
She's
it's
probably
okay.
still footing a bill from the criminal trials. And
Yes.
let's put this out there too. Karen Reed is probably pretty much indigent. And you guys
Yes.
can Google that word. She's lost everything. She's lost her house. She lost her 401k. She's lost her livelihood, her furniture. Everything that has been a possession of Karen Reed's is gone. It's
Yes.
eliminated, been wiped out because she's had to pay for her life through 2 murder trials, and she beat them. And she's gone through a lot of post-traumatic stress disorder. I'm sure
Yeah.
her life is still not back to normal. She's still fighting, in court. Her time in fighting in Norfolk County is not over until that last gavel hits. This is going to be a very long process for her, and civil suits take a long time.
They do.
From what I'm understanding, is that, insurance companies or lawyers or defendant lawyers, they always want to settle quick and just get the money and
Yes.
run. She wants this to go. She wants Alan Jackson to sit down and depose these people and have them answer tough questions. That's why you're not going to see, she's going to keep fighting this. She's going to keep fighting this.
Yes, and there's one additional piece to this, Brian, which you kind of just touched upon. In order to defend herself in the wrongful death action, she has to advance these claims against the House defendants and the entities, the governmental entities. She can't just simply rely on insurance counsel to defend her from these claims, because the defense is, I didn't do it, they did it. So she must do this. This isn't a choice. It is a choice to file a civil rights action. Let me be very clear.
Of course.
But it's really not a choice to have to bring in the truly culpable parties into your case. If you don't bring them into your lawsuit, there is something called, and I don't know what it's called up in the Commonwealth, but I'm sure the doctrine exists up there. It's called the entire controversy doctrine. You must bring in every culpable party that you wish to blame in a certain case of a civil nature. So she's not willy-nilly choosing, okay, I'm going to add to the tremendous cost of this lawsuit because I feel like doing so arbitrarily. She must do so. And in advancing her claims against the House defendants and the governmental entities, which I imagine will ultimately and should ultimately be combined with her wrongful death action, or at least for discovery purposes, streamlined together, she's going to outlay hundreds of thousands of dollars, if not more. So I mean, I'm respectfully saying this. Anyone who thinks that, oh, this is all covered and this isn't going to cost her anything, or it's all on a contingent basis, that's just not accurate. I apologize to anyone I might be offending by that, but that's simply not accurate. She
Todd,
needs
anything you want
help.
to add here, or?
No, I'm going to double down on what Nan said. Cases that I work, the defendants are called in as part of those depositions. There are court stenographers that are there. There's, layers and layers of people involved behind the scenes, not just the attorneys, layers and layers of people involved in the scenes, and everything costs. Everything costs, and nothing is on anyone's dime, except for the plaintiff carrying the foot in the bill.
Yep.
Let's take a quick look. I'm going to pull up the legal filing just to see what, I'm not going to read through the whole thing, but I want to just read a couple of the paragraphs here as to what her position is. So it says, and we'll go to line 2 here. Karen Reed did not kill her then boyfriend, Mr. O'Keefe. Rather, in the early morning hours of January 29th, Mr. O'Keefe was killed by the defendants, Brian and Nicole Albert, in Brian and Nicole Albert's home on 34 Fairview in Canton. That is the house. In the altercation during a late night house party with the defendants collectively at the house defendants after a night of heavy drinking. The house defendants responsible for Mr. O'Keefe's death are some of whom professional experience with police investigations, concocted a plan immediately after the altercation to avoid culpability and to frame Karen Reed. Rather than call first responders to help, among other actions, the House defendants conducted a Google search for information about costs long to dying cold, and then moved Mr. O'Keefe's body outside and placed him on the Alberts' front lawn near the road to make it look like Mr. O'Keefe was hit by a vehicle, and then he died in the snow, without ever coming into the house that night. Mr. O'Keefe's body remains on Albert's front lawn until Karen Reed found him later this morning. Wow. Super, super powerful opening in that lawsuit. What do you think, Todd?
I concur. Just, it's all laid out. It's all articulated there. You don't need a high level of education to hear how that story is being developed.
No, I agree. And we'll just go back to it really quick here. So it says, from the beginning, investigators, the MSP allowed the House defendants to direct the investigation away from themselves and towards Miss Reed. The House defendants were well connected to a close social group with strong ties to law enforcement. The Alberts were a prominent family in Canton, and the investigating police officers knew them well. The lead investigator for the MSP, Michael Proctor, grew up in Canton, resides there to this day. He has been and remains close personal friends of the Albert family. The House defendants, Brian Albert, was longtime Boston police officer, and the House defendant, Brian Higgins, is an agent with the Bureau of Alcohol, Tobacco, and Firearms and Explosives, the ATF.
I think Brian, a lot of people in support of Karen saw themselves in her shoes. Like, that could be me being railroaded. And if this new jury takes on that same sentiment, you're gonna see a lot of different changes here in the outcome of the civil cases.
Right. And it's a different burden of proof. So it'll be 51%, meaning preponderance of the evidence. If this civil jury determines that by 51% or more that she was culpable in causing the death of Officer John O'Keefe, then they're going to tag her and possibly the bars with a verdict, and it will be apportioned based on percentage. So it's very important that she vigorously defend that wrongful death action. And then as far as her lawsuit affirmatively against the House defendants and governmental entities is concerned, this is her opportunity through this pleading, which kicked it all off, to tell the story. It will be much more outlaid and intuitive as we've read through that pleading. I'm sure all of us have seen it or listened to a content creator read it. It's going to be looked at in a different lens, and she will have to show a jury and prove to a jury by a preponderance of the evidence, meaning 51% or more, that they are culpable based on different percentages. For example, a jury may find that some of those defendants are more culpable than others. They could find that, for example, Brian Higgins was more culpable than Jennifer McCabe, or any mixture of the like. They are allowed to do that. And it's extremely poignant to read a pleading like this and then approach the civil lawsuit and say, let's see how it shakes out with depositions, interrogatories, and the like. It's also my personal opinion, they're not going to sue anyone for defamation. I do not see, I figured it was worth mentioning, I do not see any viability of the House defendants suing or countersuing anybody for defamation in this action, because that would be a tragic mistake for them to do that, and a foolish one.
Hard to prove.
Mary's chiming in here, and she says, some people look at Karen's process as they do a movie. They don't educate themselves on the layers upon layers of how this all works. They use Twitter in the ignorant of sources of ignorant source of information. And I completely agree. I mean, it's like
I
the
do
Wild
too.
West on Twitter. It's just,
The amount of bad information that's in circulation around this, and I say that because having followed the case, having been interviewed in mainstream media on the case, you have to keep up with accurate information. Surrounding ourselves with knowledgeable people like Nan, Mark Betterow, and the others that are in the thank you, Nan, that are in the know. If you don't know any better, you can just take all that bad information in and run with it, and just stay ignorant and misinformed. So people, do your homework out there. Question everything as you hear news, even if it's news that's favorable to your position. Question it.
Agreed.
I love that. And then TJ says, so many don't understand the costs associated with the facts. Karen is still fighting for justice for John O'Keefe. The civil suit will find more information about the culprits, the DA, and the cops, etc. That's kind of the mantra of this whole theme that we did tonight. I mean, continue the fight in the civil trial. It ultimately gets to that end point of getting justice for John. And it's going to still be a long battle. This is not going to be something that's going to end, in the next 30 days or the next 6 months or a year. It's probably going to be a very long ongoing process.
Right. I think one of the first cracks in the wall was after the second trial, the interview that Lally was on, and they were questioning about records and why didn't you get, this was in the Miles King case. Why didn't you get records and all these different things? I think that was the first crack in the wall as far as exposing the DA's office. We know about Proctor State Police from that portion of the investigation, but we really didn't hear a lot about the DA side of things from Morrissey to Lally.
Yes.
Good point.
And I've heard people buzzing about that the civil case or cases are not that important. What was important was the criminal defense and her acquittal. I, in theory, agree with that the criminal case is the most important. However, just as you gentlemen were saying, what will come to light in the civil case will be not only revealing from a substantive curiosity standpoint. We may get some answers that we've all been demanding and wanting to know, but from a systemic trying to unveil corruption and misconduct, trying to get that accountability that you were discussing earlier, Todd, trying to really change the paradigm. That is why these civil actions that Karen is involved in now are really pivotal. So while I don't live up in the Commonwealth, if I were a constituent up there and taxpayer, I would actually be quite interested in the ramifications and substance of the civil actions. While it doesn't mean life or death for her or incarceration versus freedom, we're going to get answers and hopefully more revealing change. Just like we're talking about all of these different topics tonight, it's going to keep unveiling itself.
Yeah, I love this by Blessed Beyond. She says, Karen Reed moving in silence is the best move for her. I respect that. Karen, if you're watching, girl, you got this. I get it. We get it. You got this. Aussie Insider checking in. Hello, Aussie. How are you? She says, I was watching on the big screen and just had to drop in and say hi to Todd for his sage words. Thank you so much. I appreciate that. I know Todd appreciates that. Real quick, Lucy says, Nan, can Karen talk about the sidebars, or will she have to wait until they're released?
I don't know, because I don't know if there's a current protective order governing any period of time before they're released. That may have been in the order that you were reading, Brian, which I never read that order. But the short answer is I don't know. But I would imagine even if she could talk about that before they're released, she won't. Because honestly, the documents will speak for themselves. If I were her attorney, I'd say let them come out and let the document speak for itself, without kind of adding your own commentary to it. Yeah.
Yeah. Let's see. Sunshine says, oh my God, you guys are spot on. Karen, do you? Thank you so much. Appreciate that. I don't know. I mean, it's going to be very interesting. You know, she's got another hearing, December 21st. I think her next, am I right? Or the 19th? The 19th. December 19th is her next hearing. I don't know if it's going to be virtual. It's going to be in person. I have no idea. But I do want to play this really quick before we end the show. Alan Jackson getting a little spicy in the hearing the other day. We'll play this really quick, a little back and forth with the judge. This was pretty good. Hang on.
Honor, it is for me. I have a pre-existing hearing scheduled that day, but the 16th and the 17th I'm open.
All right.
If I could,
16th to the 7th.
if I could have just a moment, Your Honor, to confer with my client. The 16th and 17th don't work for Ms. Reed. Either the 18th, I know that that's bad for Mr. Waters. The 19th would work.
19th works for
Attorney
me.
Jackson, I can understand Ms. Reed wants to be there at every matter, but I don't necessarily think there are constitutional issues relative to the civil case.
I agree. I'm not suggesting that she has a constitutional right to be there, but I know that she wishes to participate in her own defense, and she would like to be there if we can accommodate her schedule.
Right, but if the court starts having to accommodate every party's schedule, it would grind the courts to a halt.
I understand. I get that. There's only one defendant, though. What that's
Well,
worth.
there are other defendants in this case.
Your Honor, for what
Alan's
it's worth,
just
I
not
can also do
listening, just
December
like
19th.
Will it be remote, Your Honor, by Zoom? I have things that week, but if it's going to be remote by Zoom, then I can try to, I can definitely be available and then not worry about moving things around on the week.
All right. I just wanted to play that little. I just love Alan.
Yeah.
He's just like, I'm not listening to the judge.
Yeah, when I heard that originally, just to give some color commentary here, it
Yeah.
is quite common for a defendant to want to be present for every
course.
single proceeding. And while there may not be a constitutional right to be part of those proceedings, it is a professional courtesy to afford that to her. He did brush off the judge after that point, but
It's like,
and he wasn't being obtrusive or unreasonable. It appeared to me, okay, while she wasn't available December 16th or 17th, she, through Alan, offered 2 dates immediately thereafter in the same week. So the judge was kind of dismissive of the fact that, okay, maybe she's being obstructive, and she's not. And while there are other defendants in that lawsuit, they are institutional defendants. They're the bars, the dram shops, as the law would say. They're not going to want to be there, but she does want to be there. So I find this a little bit annoying, because it would have that's something on my planet where I practice law. No judge would ever do that. They would say absolutely no problem. It's also like a holiday week. It's the week leading up to a major Christian holiday. So I love the fact that Alan kind of pushed back at that judge. I would have done the same thing. As someone just wrote, I need Alan Jackson in my life. I do too. I do too.
I love that. I love it. I love it. I love it. Yeah. Well, very, very interesting conversation. Again, I think this is going to be a long process. It's going to, it's going to take a while for this to get to the courts. More information will come out. We'll be watching and we'll be talking about it. Todd, anything you want to add before we end?
No, it was a good show. We covered a lot of topics, and there will be more.
There's always more. Well, by the way, real quick, and I always keep saying like we're going to end. I saw this tweet from Mark Betterow. This is interesting. If anyone has a documented proof that a taxpayer-funded public servant who worked for the Mass State Police, who investigated and or is a witness against Karen Reed or Aidan Carney, is actively promoting a fundraiser for the witnesses adverse to the above named individuals, please send me and Breda Law copies ASAP. Thank you. Yeah.
Interesting. Okay.
Yeah, I think there's been some talk out there that, I don't know, someone related to someone or one of the McAlberts or whatever are promoting the website to get money for the McAlbert civil funds. So it was interesting. I saw that pop up today. I was like, oh, this is going to get really interesting. So
yeah, I mean, there should be really no intermingling of interests here. If there's anyone who is an investigator or participated in the investigation of Karen
Yuri
Reed,
was.
yeah.
Ooh, look at that. Yuri was doing it. Interesting.
Yeah, in fact, I want to say as I was working today, I thought I saw a tweet that he somehow shared that post or some post about the fundraiser. That's a big no-no. And not only from a legal perspective, but it just creates what we call an appearance of impropriety. It smells bad. So there's no reason why an investigating officer should in any way be haranguing for financial support for any defendants in a civil action that's being instituted by Karen Reed. That smells really bad.
Oh, and I'm sure that's pretty interesting stuff that Alan Jackson's going to want to get a hold of as well, too. So,
yeah, wouldn't be the first time, in my opinion, that Yuri Buchanan was a little reckless with probably his cell phone. Because if I recall, he liked, meaning the like thumbs up emoji, to some of Proctor's inappropriate texts. So, that if you're reckless in how you're texting, you're reckless in how you're doing your job.
100%.
I agree. Oh, you're glitching.
I'm glitching. What a way to end.
Those are man's outro glitches.
Yeah.
That's right.
Got to keep you guys wanting more.
I want to thank my guests for this evening, Attorney Nan Gallagher and retired Mass State Police Todd McGhee. We do this on Monday nights in our Monday night conversation. And, if you like, great content like this and good conversations where we just kind of throw things around and, and talk about these cases and shine some light on it, come hang out on Monday nights. We're here and we enjoy everybody here watching in the chat. I'm going to let both of them go, and then we're going to do the outro. I appreciate both of your time this evening. We'll do this again very soon.
Good night, Brian. Good night, Nan.
Good night.
Good night, Jack.
Good night.
Yeah, and happy Thanksgiving, everybody. Happy Thanksgiving.
Same to you.
All right, we'll talk soon. All right, that is it. That is another edition of LTL in the books. I appreciate everybody watching this evening. Thank you for coming over here. If you haven't subscribed to my channel, please make sure to like, share, and subscribe. And we'll be back soon. We'll do another show really soon. I love all of you. And again, if you want to help support Karen's Defense Fund, the link is at the top of the chat. You can donate. I know it's really tough right now in the times that we're in, but every dollar counts and it helps get justice for John O'Keefe. All right, I'm out of here. Talk to everybody soon. Peace.